Welcome back to the Blackletter Podcast. We set out to create an entertaining and exciting podcast about law and business. Blackletter, the name, comes from the Gothic typeset. Over time, Blackletter became the only font that English law books were printed in. It made it harder for kind of the common person to understand what the English law books said. Blackletter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify black-letter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening. And welcome, ladies and gentlemen, to another episode of the Blackletter Podcast. With me, I have my law partner, Claire Gibson. So Claire is a partner at Dunlap, Bennett Ludwig. She focuses on both domestic and international trademarks. She has a huge portfolio of fashion trademark clients, and that's what we're particularly going to talk about today. She has 2 decades of experience. She started working at JPMorgan Chase and then went to DreamWorks Classics and then NBC Universal. She's counseled clients across a wide range of industries. Again, we're going to focus on fashion, but they include cosmetics, food, entertainment, and music. She's highly experienced in managing matters for the USPTO, trademark filings, portfolio management, all of that stuff. And her global experience with trademarks, and think about fashion, it's global, spans Europe, South Africa, Asia, Africa, Canada, Caribbean. It basically spans the whole world. So Claire is also on the executive board of the Military Spouse Bar Association. Her husband is a devil dog, what I would call a Marine. And she is the co-chair of the trademark committee for the New York State Bar Association and on the board of the National Conference of Women's Bar Associations. So all of that is crazy impressive. I don't know where to go from there except to talk about our topic today, which I'm super interested in talking to you about because you have an expertise in fashion. And I know that when I teach this stuff to my students and we talk about things they can connect with, this is one of the areas. Like the Tiffany Blue was one of my examples of trademarking a color. They're like, how can you do that? And I said, well, if it signifies the origin of something, you can't just trademark blue because you like it. But anyways, Claire, tell me, why is IP important in the fashion industry? And what are the big things we should know about?
I mean, I think you just touched on one of the most famous examples. Anytime you mention Tiffany Blue, everyone immediately knows what you're talking about. It's a perfect example to explain why these things intersect. When we're talking about fashion and brands, especially, you're buying the brand. It's trademarks in particular are source identifiers. The idea is that you have this goodwill and reputation associated with a brand. And where else do you see that more clearly than in fashion? When someone's talking about they're going to go buy a handbag, the first thing they say, are you buying a Louis? Are you buying a Fendi? Are you buying a Gucci? Like we're not talking about the size of the handbag. We're talking about this particular brand because it has a reputation. We know that it's going to be of a certain style. We know that it's going to be of a certain quality. When it comes to fashion, the brand literally carries the goodwill that we as lawyers talk about in a very, very profound way.
I can't begin to tell you, Claire, when you said all of those names, how like in the back of my head, I start cringing because my wife, when we were in Paris, went into this store
coming up.
Yeah, it begins with a C, and she bought a handbag this big, and I don't even want to tell you how much it cost. But it's like,
was it Chanel?
It was. There's like, you could get 10 cows for that. And you got a piece of one cow, and it's pink. Like, so like, I didn't lose my mind, but I was surprised at the. So
I don't take my husband shopping for handbags. He doesn't.
She didn't take me. I just saw it. I was like, what is that? And anyway,
like, cover your eyes. But
yeah.
That value is everything. You're getting quality, you're getting hand stitched, depending on, the brand. These things based on the brand reputation. And that's exactly where the intersection between fashion and trademarks comes. It's just, there's no way to kind of separate the two. You're not just buying a handbag. You can buy a $10 handbag from Target. It's going to hold your cell phone and your gum and the same way that the $100,000 handbag from Hermes is going to. However, when you buy that Hermes handbag, you're buying that brand, you're buying that trade dress. That's what you're purchasing.
So what are some, and I'll just point out financially, you would have $99,995 extra dollars with the Target handbag in your bank account. But I totally get it because it happens. So, and there's so much value and so much fighting. So tell me, what are unique considerations in fashion that you don't see in like a trademark for like, I don't know, like a water bottle or like the iPhone? Like what in fashion, what are things that you run into?
So we're talking about kind of this trade dress. When we talk about trade dress, we're talking about the shape of a product. When any, red-blooded American woman sees the shape of an Hermes handbag, we know without seeing even a label, without seeing even the word Hermes, we know what handbag that is. We know where it came from. And that in and of itself is the definition of what makes a trademark. You look at it and you associate that particular shape with a certain source. And so when it comes to what we call functionality issues in trademark, inherently, you're not allowed to own or register a trademark for a product shape that is functional. We talk about, putting your gum in your wallet in your hand, your cell phone in the handbag. So when you're looking at protections for those types of goods, you have to consider the fact that the actual shape of the bag can be protected, but you can't have protection for that functionality aspect. So your IP attorney needs to be able to kind of navigate those issues when it comes to filing for the registration. Not every shape is necessarily going to be protected if the specific issues and specific features of the shape are only functional. The design elements are what are being protected. The unique aspects of the design are what's being protected. And so that's something that you see very, very common as an issue when it comes to just apparel and fashion in general, more often than not, even when it comes with clothing designs. I worked with a client who they had a very, very unique design for, let's term this kind of a wearable sleeping bag. And because it had that functionality refusal initially, because, hey, this thing is designed to keep you warm, that you can't own a trademark for that. We were able to overcome that refusal because we were able to show that the design aspect of it is not functional. There's no need for it to have the particular shape that it had, and the client was able to secure a registration. So go ahead.
Oh, was it like a poncho blanket thing?
No, it's literally, it kind of looked like a moon suit.
Okay.
Yeah. And so that, and as you just said, it could have been a poncho. It could have been any number of other designs, and the functional factor of it would have been the same. Yeah. All of those shapes could have kept you warm, but the client's design was so unique and it didn't serve a specific functional purpose. And that's the only reason we were able to secure the registration for that.
So your argument, just so that our listeners are clear, your argument was that there are 10 other ways to do exactly the same function. We picked this shape because of the trade dress value, because of the look, because of people identifying us, right?
It was purely stylistic and purely design based. Yes. There was no functional need whatsoever for it to have the particular shape that the client went with. And that shape also, again, this smaller company and in a very kind of niche area of fashion, if you want to call it, kind of fashion hiking, I don't know. But they were in such a way that it was associated with their brand because no one else had come up with this particular design or even this particular concept for having this wearable sleeping bag apparel item. So those functionality issues are things that you really need to think about from the outset. I would say ideally your design department needs to be working with your attorneys to see where things are going with that, but the functionality issues are definitely recurring. Other things that we see very often as well with apparel industry are eponymous brands, meaning brands that are named after a person. We're talking about Gucci, we're talking about Michael Kors, we're talking about Kate Spade. And so under trademark, there you go. Under trademark law, when you're doing a filing, you can't have a trademark that is primarily a surname. That's not allowed under the Lanham Act. And so
how do they do this? Yeah. How does Gucci get it?
Yeah. To give you the lawyer answer. So if you combine the surname with a first name, so Kate Spade, for example, you will be able to, and Michael Kors, another famous one, you will be able to get the registration. But when you're talking about some of these older brands like Gucci, where it's just Gucci, right? You have that singular surname, they have acquired distinctiveness. And so they're able to kind of get around that refusal issue because they're able to prove that the brand itself is such that it's associated with this particular source.
So let's
So
talk
it
about
depends
that
on where
real
you
quick.
are in the process.
Yeah. So let's say, so acquired distinctiveness is a term of art in the trademark world. And I think our listeners would love to know specifically what is acquired distinctiveness and how do you acquire it? What's the standard?
So acquired distinctiveness specifically speaks to the fact that the brand has been in use for 5 or more years and that the general public associates this particular brand with a particular source. So Gucci obviously is a very, very old brand. And House of Gucci, I remember watching the movie. We're on maybe 4 or 5 decades at this point. So by
Yeah.
the time they
60s,
would
50s,
have
60s.
yeah, and originated in Europe. So by the time they would have applied for trademark registration in the US, the brand had been long established, the reputation had been long established. And what would happen is that the attorney filing the application, I mean, we could probably look through the USPTO apps and see what's in there, but they would have filed a claim in addition to the initial application for what we call a 2F, which is the Section 2F Lanham Act distinctiveness requirement, and provided evidence. And the evidence can be anything from press to marketing budget to anything associated with how reputable the brand is, and showing specifically that the general public associates this particular brand with a particular source
Right.
of for the goods and services or what have you. And then from there, assuming that the evidence is sufficient, the brand would be allowed to register, despite the fact that without that evidence, it wouldn't be eligible for registration otherwise.
Gotcha. Now let's talk about what is a natural zone of expansion in the fashion industry. That's sort of a unique, that's not every kind of trademark. But
One
what does
thing
that
I
mean in
want to
fashion?
touch on first with the surnames.
Sure.
And this
Yeah.
is something people need
Do
to
it.
think about at the outset as well. If you're going to name your brand after yourself, think about what happens in 10 or 20 years when you possibly want to sell the brand or license the brand. You're basically giving up your name. And I don't think that a lot of designers think about that at the outset.
Right.
It's their baby. They're birthing this thing and they're in love with it and it's everything and they think they're going to do it forever. And even if they do it forever, what happens with the next generation? You've got your name associated with this. And it's just, it's something I like to remind clients of. It's something to think about, because if you do grow the brand and then sell the business, you're in such a position that you're not going to be able to then use your name on any other business in that
And
same
Claire,
industry.
one thing that reminds me of is you're also kind of signing your own morals clause like athletes have. If you use your name for your brand, aren't you kind of stuck with having to always be a good actor? If you screw up in life, DUI or whatever, it
You're
affects your brand.
disparaging your brand. Yeah.
I mean,
And it's not your
crazy.
personal
That's a
brand.
huge risk. Yeah.
It is a very large risk, and a lot of, especially young fashion design, they're not thinking about that 20, 30 years down the line. And so what I've encouraged clients to do in the past, like, sure, use your name, but a lot of brands you'll see will have, say, Blackletter Podcast by Dunlap.
Right.
And that way you kind of have, a multiple double branded situation, and you have more flexibility there, as opposed to it just being, Michael Kors. That's just who it is.
Right. That's why we're not the Dunlap podcast. I'm with you. Yeah, 100%.
It does matter. So that's just one little small asterisk that it can turn into a very large deal later on, but something to just think about. And there are some fashion designers that have specifically chosen to have their trademark registrations owned by themselves personally, as opposed to owned by their business, in order to avoid some of the issues that can happen with that. Say, for example, the business is acquired forcefully and the trademark is owned by the business. You're kind of locked into a situation where you don't have many options. So it is something that should be thought about, and it should be discussed with your attorneys while you're filing these trademark registrations. You have the option to file it in your name personally and then license it to your business. There's different workarounds, but it's something that should be discussed.
Okay. No, absolutely. So let's jump to natural zone of expansion. That's kind of the next topic on my list of what is that all about?
So when we talk about spheres of protection in trademark, we're thinking about think about it literally as a bubble of protection around a brand. And natural zone of expansion, specifically for fashion, if you come up with, an apparel line and you're designing, ladies' dresses, it's not unreasonable to think that in, 5 or 10 years, you might also be designing handbags. You might also
Right.
be designing shoes.
Different
These
classes
days.
of goods and
Exactly.
services.
And these are different classes of goods and services. And you may not have necessarily thought about that at the outset, but it is foreseeable in some ways. And so you do want to think about it at the beginning. Also, these days, we see a lot of fashion brands that also have perfume lines. They have makeup wear. Now you're
Right.
also starting to see a lot of those brands expanding into supplements. You have supplements for your skincare, your hair care. And so it's very, very easy to kind of see this expansion from, dresses down to literally supplements. And so when you're doing clearance in particular for fashion brands, your attorney
Right.
really wants to search broadly. And I often recommend to clients that we search across the board for all goods of classes and services, simply because thinking about the longevity of the brand and, in hopes, of course, that it will be successful, you want to make sure that you're not limiting your ability to expand your brand into other areas and trade channels that your clients and your customers are interested in. And so once you're discussing these issues with your IP attorney, that it shouldn't just be, oh, well, I want apparel in these class 25. It should be, here's the brand, here's the focus, but let's also look at where this could be in 10 or 15 years.
Yeah, I mean, didn't Coco Chanel start as a perfume only? Like, so there's the story behind it. And then obviously the handbags are probably bigger business for them now. I don't know. But it seems like that's one of those. I don't like, I keep settling on that.
Clothing,
Yeah.
it's the perfume, it's the makeup. You don't want to know how much the lipstick is. It's all of it.
I didn't even know they had that other stuff. I know about the handbags and the perfume. Now I'm worried. I'm not going to check. Oh my gosh.
Just don't worry about it. Don't worry about it. I'm going to say your wife. Yves Saint Laurent, for example, is one of my favorite brands. I mean, I don't look at I want to say the lipstick's probably like $50 or something. The handbags will run you over $2,000, easy, 4, 5, 10 grand. The shoes, yeah. Don't look at the bill.
We called them in business school Lieben goods. And I don't know if you've heard that, but basically kind of like lawyers, snob goods, like the polo shirt that has the Ralph Lauren on it, that was made by the same guy who made the Target polo shirt with nothing on it, but you're paying $80 instead of $12. So I don't know.
Maybe the handbag's better. Brand reputation. No, and it's also, and I'm going to say this, it's also an investment opportunity.
Joking. Yeah.
Because the Chanel handbag is going to appreciate in value in a way that the Target handbag is not. No offense to Target.
You sound like my wife. Look, she said the same thing.
She's right here talking to me. Yeah.
Oh my God. So, okay. So let's talk about the steps. Yeah, I know. She said that too. I just was like, really? Anyway, but I believe you. Totally believe you. I know it's a thing. She showed me the internet and the whole thing. Yeah. So let's talk in fashion. I mean, gosh, they make a lot of money, so they're doing it right. So let's talk about the steps involved in clearance, specifically as it relates to fashion issues. What are kind of, specific risks and some case examples in clearance searches and kind of in the fashion space?
So like I was saying, first thing you want to do is make sure that you're searching very broadly. You also want to be looking at trade dress considerations, not just the name of the brand itself, but also just design aspects. There is a number of famous, and I want to say this litigation is still going on. Kim Kardashian, household name at this point, was sued by the estate for Donald Judd. And specifically, the claims I want to say were trademark infringement, copyright infringement, false advertising, specifically because she created or had someone design a series of furniture items for her office launch for the Skin by Kim line. And the specific designs were allegedly confusingly similar to the design pieces by Donald Judd. And so that litigation is still pending. Now, if her attorneys, and I don't even know if she spoke with attorneys while she was initially doing this, but
not good ones, right?
It wasn't me.
Yeah.
As the saying goes. But what should have happened, and this is why I mentioned earlier that there should be ongoing conversations between development and attorneys for this specific purpose. When these products were being designed, there should have been a conversation with regard to source of the designs, inspiration for the designs, what makes the designs unique. Are they going to apply for trade dress for these designs? All of these things need to be considered because otherwise there's serious exposure and liability, which is exactly what happened. Not only is she being sued, but the design company that she solicited to create these designs is also being sued. Now, I'm not sure if Donald Judd's estate has copyright registrations for those designs, which is, I want to say 2019 was when that became a requirement for enforcement. But they actually would still have claims under trademark law as well, specifically for these designs, if they can prove that even at common law, the designs and the trade dress for those designs are associated with this particular designer. So when it comes to clearance, you really, really have to be thorough. And obviously, this, and we were talking about tables and such. This is not fashion, but the same concept applies when it comes to these kind of design and visual types of what I still term art. I think an Hermes handbag.
I mean, it's kind of fashion because the tables are fashionable, and that's where they derive their value. The Judd table. I mean, that's the hallmark of the fashion industry, right? The value of the brand. Yeah.
And what the visual aspect of it. And so clearance for it needs to be thorough. There needs to be an ongoing relationship between the IP attorney and the designer. There's just no other way, because you don't want to end up at the end of the process with the design that's either infringing or otherwise not protectable.
Right. 100%. That makes a lot of sense. So let's talk about syncing IP protection with product launches themselves and how the USPTO system works. I think we have a very unique, not very unique, but fairly unique as compared to the rest of the world, the 1B ITU intent to use registration. How do you use that in the fashion space? What is the value of that? How does that work?
So
Yeah, go ahead.
Yeah, I first started using it, I want to say, in the cosmetics lines, because a lot of cosmetics lines will come up with their concepts for spring launches and new makeup the year before. So what is this? We're in September. They already know what new shade of bronzer and what it's going to be named for spring. You're like, what? What is going to be
I don't
named
use
for
it,
spring?
obviously. Yes.
For spring 2025. And so what's really, really great about our US process for trademark registration, like you said, is this intent to use application. And so under US trademark law, you're allowed to file your application, get what's called priority rights in the interim, and you have up to 36 months to prove evidence of use in commerce before you have to finalize that registration. This means that when your concept designers are working on, in 2024, for whatever is going to be launched in 2025, we can go ahead and file those applications and start securing ownership of those brands long before the product is even on the market. I have clients also, specifically cosmetics, that nail polish colors. Nail polish is a huge industry for that particular, because every year you get a new palette of colors and the palettes are always named. And so if it's very popular, sometimes they'll become recurring. You'll also find vintage colors. And so you want to make sure that you're thinking ahead to secure the name of those brands and make sure that your registration applications are at least pending before you even put the product name out there. It's a really, really good way to kind of get ahead of the curve in that way. Now, obviously, when you file the application, the brand name becomes public record. But at that point, you've also kind of secured your place in line for ownership ahead of your competitors. So it gives you a bit of an edge in that way.
So it gives you a bit of an edge. What if somebody comes along, though, and sees your nail polish name that you filed in ITU and starts selling under that brand? Do you have any recourse? What is the rule there? So
again, you've got priority rights because your application was pending.
So first to file, so you get priority at the USPTO. So I have seen this a lot with beer. So we have a lot of brewery clients and distillery clients, and they will come up with 16 new seasonal beer names before they're released and file trademarks and do about half of them and let half of them just go abandoned. So same kind of thing. It's interesting. So actually, listeners, what Claire has said is if you're launching products for 2026 or 2027, let alone 2025, you should be filing now if you know what the brands are, because first to file, you want to get priority on the register, on the USPTO register. So
And
awesome.
you can start enforcement even with that pending application. You at least want to extend a cease and desist out because you're putting someone on notice. And then once you've actually secured your registration and they've continued to infringe on the brand, you're in a lot more advantageous position than if you've said nothing.
Absolutely. So tell me now about so fashion the world is now global, but especially fashion because it's so mobile and is sold across national lines every day. Even if you're in the middle of Wisconsin in a small town, you can sell fashion to Europe. So how do you deal with that? Because trademark registrations are national, confined by national borders. How do you use international registrations in this space, and how are they what's their value?
So you've got a number of tools and a number of different ways to kind of go about this. And this also depends on whether you're talking about your house brand, which is like your primary brand, or whether you're talking about different product lines or clothing lines or makeup lines that you're putting out on an annual basis. It would affect which way you approach this. So you can either file your U.S. application first, and then if you're expanding into different markets, you can file an international registration based on your U.S. registration. Or if, and this really applies to kind of the larger companies or even some of the mid-size these days, like you said, with access to the internet. If you know you're targeting specific jurisdictions, say that you're launching a sale of products in the US, UK, and France at the same time, you can go ahead and file an international application that will cover all of those jurisdictions and have them pending simultaneously. So which approach you take depends on, your launch intentions and your launch schedules, whether it's by dated jurisdiction, what have you. But you have a number of options available to make sure that you're getting protection in multiple jurisdictions, whether you start in the US and then you expand, or you start from the outset with an international application and then designate specific jurisdictions. Either way, you want to make sure that you're filing ahead of having those products launched because you want to make sure that your enforcement is ongoing.
Gotcha. So question, if I am a U.S. fashion brand and I only register in the U.S., I register my polo shirt company, call it Little Globy Thing Polo Shirts. That's our brand. And it's this design, terrible, but that just, for example, and somebody in the UK, before I get a chance to file my U.S. application under WIPO or whatever, however I decide to file, before I file there, they start making my Globy Thing shirt because they love it and they start selling in the UK. What happens? I mean, do I still own that trademark? They copied me. So ask me my questions. I'll tell you about my brand and what happened.
Were you selling in the UK? Do you have any sales in the UK? Do you have any
Not
products?
yet. I had a plan. I had a manufacturer there and a distributor who was going to do it locally.
And no sales.
No sales. No, I wanted
no pending
to.
application.
No, I didn't file. My attorney Claire told me to, but I didn't do it. Am I done?
You're done.
So that means, because I didn't listen to you, Claire, that somebody is selling my brand in the UK and making money off my amazing brand.
It's not your brand because you didn't have any sales and you didn't file an application. So it's not your brand.
In America.
In America, not in the UK. That's and I tell clients all the time, and I said this on another webinar recently. Lawyers are not your enemy. If you've paid an attorney to look out for your interests, we like delivering good news. We want to set you up to win because it makes us look good. If your attorney is advising you to take specific action, don't assume it's just because we want to collect billables. It really is in your best interest to take the advice that you're paying good money for. More 100%. Often than not, we're setting clients up to make sure, and we're thinking long run. We're not necessarily thinking what you're doing today or tomorrow. We're thinking months, years down the line. It's just better to be proactive. Reactive costs too much money.
100%. So talk to me about now, and I know we're running short on time, but let's talk about enforcement and counterfeiting. We were talking about it before the show a little bit, but what options do fashion brands have for seeing who's stealing their stuff and checking on that, And what options do they have for enforcement beyond just themselves going on Google and Googling things over and over again? Are there services? Are there ways to do this? Does DBL do this? What can clients do? Yeah.
You just triggered me because I'm in the process right now, kind of walking a client through this. Unfortunately, when I advised them, I would say 2018, 2019, it's like, you need to be using these tools. And they were more focused on the business at the time. And now we're kind of playing whack-a-mole with the infringers, and we've got some TTAB stuff pending. There are tools available. DBL absolutely will work with you on making sure these tools are properly set up and that you're actively policing and enforcing your brands. So the first and foremost would be trademark registry watch services. Yes, there are services that specifically watch the registry for marks that are identical or confusingly similar to yours. Reason being, if a trademark is a source identifier, you do not want to be one of many. You want to be the only. And while the USPTO does a really good job of preventing other marks from registering that are similar, that is not always the case. They are not always able to catch everything. And also, they don't know what your expansion plans are. So you want to make sure that you're taking it upon yourself and doing the due diligence that you need to be doing to watch the registry. The other thing about that is that you're legally required to anyway. Under the doctrine of latches, if you're not actively policing your brand, you lose your rights. This is equivalent to squatters' rights. If someone's in your vacation house and you don't kick them out, after a while, you can't. It becomes a lot more cumbersome process. So that's the first and foremost. Now we also have these really great tools that will specifically watch social media, websites, and online e-commerce marketplaces. Lots of people are selling their goods, apparel and otherwise, on places like Amazon, also on Shopify. Instagram now also has the shop features. You need to be actively and intentionally monitoring these sites to make sure that people are not using your brand or confusingly similar versions of your brand to sell their product. Sometimes, and this is speaking specifically about counterfeit goods, they are not just selling their products, they're also selling counterfeit versions of your own product under your brand.
Gotcha.
And if you are not aware and you're not actively and intentionally doing something about that, it can not only cut into your profits, but you can also end up losing your rights to your own IP. One tool in particular that's really, really good for counterfeit goods, and I think also with a lot of apparel brands start doing this, is Customs and Border Patrol registration. You can register your IP, especially your trade dress and your brand names, with Customs and Border Patrol, and then you're actually able to kind of use a government agency as a first level a bit of prevention in that sense. So you want to make sure you're kind of approaching this from multiple steps and multiple directions to actively and intentionally make sure that you're out there looking at and paying attention to, and have your legal team paying attention to what is being used and whether any of it is counterfeit or trademark infringement.
So CBP doesn't catch everything. I guess that's the first. So they miss.
Neither does the USPTO. That's why I call it first level preliminary. Yeah.
Makes sense. So having a firm watching for you is probably the best idea. Other question about CBP. So it's true, isn't it true? You have to have a trademark registration for CBP to do anything. They will not just accept you telling them it's your brand. So,
No. You do need a federal registration, not just a trademark. You need a federal registration.
Yeah.
Because otherwise, there's not even a process by which they're going to pay attention to you if you're trying to operate on common law rights. That's just not a thing. So you need a federal registration issued by the U.S. Patent and Trademark Office showing that you are the owner of a specific trademark or trade dress, in order for you to register that with CBP for them to enforce, or at least begin to attempt to enforce and prevent the importation of goods or brands that are infringing or counterfeit.
Gotcha. So let's talk, and we are probably out of time, but maybe you can do it in like 30 seconds. Because I'm curious about this. What are co-branding agreements? Talk about a little bit about co-branding agreements and trademark registrations for co-branded goods, because I think that's fairly unique to the fashion industry. I haven't really heard of that elsewhere. So I just like to touch on that. Sorry, we're making it a little longer than I told you.
You're good. So co-branding agreements, and it depends on different areas of fashion approach this differently. I have clients, for example, that are kind of streetwear brands. And what you'll see, especially if you're a sneakerhead, I'm not a sneakerhead myself, but I have friends who are. And
Heard of
on a
this,
note,
yes.
another collection item, apparently a lot of these sneakers really appreciate in value. So you will see co-branded sneakers, for example, whether it's a Nike or a New Balance or what have you, where you'll have an urban wear designer working with a larger manufacturer, and they will co-brand a new launch of sneakers and sometimes apparel items as well. Normally what happens is that a lot of the manufacturing costs obviously will be taken on by the larger brand, but you'll have licensing agreements between the two entities to allow for the use of both of their brands on the launch of this new product. Now, whether it's going to be for one season only or multiple seasons, that'll be determined in the licensing agreement. And then also, depending on which entity is doing the manufacturing and sale of the product, you may want to also register that licensing agreement with the USPTO, and depending on the term of the agreement as well. But yeah, those are always fun products to see launch. And there's a lot that goes into it as well, not just in terms of the product itself, but also the marketing aspect, because most of the marketing there as well is going to have both brands on it. So you want to make sure that you're going through and there's some degree of quality control and oversight. You don't want to end up with a naked license situation, right? Which is very rare. More often than not, both of them are, it is a collaboration. They're working together to produce this product from marketing through launch and sales.
So final question, and this is nothing to do with trademarks. Sneaker heads, shouldn't it be sneaker feet? Like, why are you sneaker head? You don't wear sneakers on your, I've heard the term. I don't, sneaker brains. Like, what is it about sneaker head? I don't know. It works.
I don't know that I am actually young enough to know the answer to this. I want to say it's kind of like the term like earhead or like whatever your focus is, like that's on your head, like that's on your mind. So sneakerhead being that's your thing, like that's what you're into. I'm probably going to get called out by Gen Z for this.
Well, I saw the Mahomes commercial where Patrick Mahomes like, yeah, I'm just a sneakerhead or something like that. That's where I first heard it. And my son has a friend who buys sneakers and resells them. And I'm like, that's weird, but apparently it's a thing. So
it's a really big thing. Like people will get online, I'm here in New York, and anytime, randomly you're walking the street and you're seeing 200 people lined up outside of a store, it's very often it's fashion related, almost always. It's either a sample sale or something.
Oh my God.
But very often it'll be for the purchase of certain sneakers. And once those things are sold out, apparently you hold on to them for a little bit and then you can sell them for 10 times the original purchase price. So,
what? I will say, you just brought something up. It used to be when I was younger, you'd stand outside of the store for the release of a video game. That doesn't happen anymore because nobody buys a video game. I didn't do that, but it was a thing. Like people would line up for this. Now, the only time I see it, I was in London with my daughter before college last year. And outside of it was like Versace or something like that. They were having a release. And there were 50 people wrapped around the block. And I was like, what? So like, I don't know, maybe more. This is way more. Yeah, I just walked past it. I was not interested. And I was not interested in having that. We stood outside of fashion stores. I can't remember. There's an iconic London one where my daughter ended up buying a dress. Oh my God. But we had to wait in line to go in to buy a dress for a lot of money. We had to wait in line I was like, how did they do this to us? How did they convince us, or my family, to stand in line outside?
Tell you that you need to apply to purchase an Hermes handbag? You have to apply.
You do? What?
Yes. There's actually pending litigation right now against Hermes, specifically because the basis of the lawsuit is that you should not be required to make all of these preliminary purchases in order to qualify to apply to purchase the Hermes.
I didn't know that. That's crazy.
Yeah.
Sorry.
I know. I figured out.
Sorry. That's interesting. They're not a client, so I can say that's
May
crazy.
I please give you my money? Yes.
Yeah. Oh my
See,
gosh.
I have bought these other tokens. May I please give you my money? Yes.
They have mastered this space. Well, Claire, thank you so much. It's been so much fun. And thank you, everybody in Ether, for listening to us or watching us. If you watch us on YouTube, we're fun to look at, I think, as well, if you've listened to the show. Download us wherever you get your podcasts, iHeartRadio, Spotify, iTunes. We're on all of them, and find this on YouTube. Thanks for joining us on this episode of the Blackletter Podcast with Claire Gibson. We'll see you next time. That's all for today's episode of Blackletter. Thanks again for listening. Join us next time when we talk about more Blackletter issues in creative ways. Make sure you subscribe to the podcast so you never miss an episode, and check out our website at blackletterstudios.com.